Happy Friday night live, friends. It's so good to see you. We have two topics this week that we're diving into, and I'm sure there will be more once we get to questions. So tonight, we're going to chat and catch up on the week because that's how Friday Night Live started at the beginning of COVID. Gosh, almost a year ago when I started doing live streams on Friday nights to catch up on the week and cover the legal topics that we all want to talk about. And then we're going to cover the Girardi updates that I found the most interesting because, there's a lot of them. This hair is already on my nerves. The Girardi updates, because there are a few of them that are very interesting. The Taylor Swift case because now there are two lawsuits for Taylor Swift and court of public opinion. We have a ruling because we had a runoff, and then we have a new court of public opinion topic. So it's time. It's time to jump into it. If you are part of the replay crew, thank you. Welcome. And there will be timestamps for you down below after the stream completes. Let's just get into it. It's time. It's time. It's time to just get into it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. How are you guys doing this week? It has been a busy week for me. It's been like a worky type of a week, like business worky stuff. I've completely forgotten to share the stream. So if any of you all want to go ahead and share it on Twitter, I would be very much obliged because your girl totally forgot. I remembered to send it to the text crew, but I forgot to send it to the Twitters. So if anybody wants to go ahead and share it, you are welcome to do that. I, again, am obliged. This week, what have you all been up to? We have been we're in Middle Tennessee, and we've still been trying to dig out from being basically shut down all of last week due to snow. My kids were out of school all of last week. And then on Monday, which was wild, we moved from California over the summer. So we've never really experienced anything quite like that, which was unique for us to experience that. I did get a new light set up. So yes, you can see when I'm tired much more accurately, but it just is what it is. But I got a new light set up. I'm very excited about it. My camera's still trying, if I raise my arms too much, my camera's still trying to figure it out, but whatever, tech stuff. I love streaming and chatting with you guys. Sometimes the tech stuff, I love technology. And then sometimes I'm like, please just work, which is why I'm an Apple fangirl. So we kind of dug out this week from all of the stuff with the snow and everything. And then, the Girardi case has not slowed down. The Taylor Swift Evermore stuff has not slowed down and has kind of ramped up. But other things have been kindly quiet. So there have been no new filings. I should double check Pacer before I say that. But no, there have been no new filings before I went live in the Toddy Westbrook defamation lawsuit, which is lovely because we can just talk about other things here on a Friday night and have a beverage together. I got to have a guest last week, and all of the tech gave me issues. So here we are, just getting to catch up a little bit and talk about the topics of the day. You heard my sub counter ding while I was on Up and Adam. Thank you. It dinged while I was on Up and Adam, and then it dinged again today while I was on a podcast interview with the crew at vidIQ, which was a really fun interview. I've got to be honest, this week I've spent way too much time on Clubhouse, but yeah, we're at 87.1 thousand. We're getting closer to purple hair, I'm very excited, but we're over 87,000 subs, which blows me away. And I've spent a lot of time this week on Clubhouse talking about YouTube with other YouTubers. I really do love this platform, and I love talking about this platform. Katie, thank you so much coming in from the Facebook. I love my side part too. I am not getting rid of it. Look, I don't care if Gen Z wants me to look like I'm at a 70s costume party with a middle part. This Widow's Peak is not doing a middle part. You guys were so kind on the Instagrams with the stories that I posted about the Gen Z, like, we don't do skinny jeans, we don't do a side part, we're doing mom jeans and a middle part. I'm like, I'm still scarred from when Jessica Simpson got lambasted by all of the media for wearing mom jeans at a concert. She looked super cute, but I think a lot of us at the same age are scarred for life by how horrible people were. And then the middle part, I feel like I do. I feel like I'm going to a 70s costume party and I look like James Hetfield. Though a lot of you did say it was more Janis Joplin than James Hetfield, which I do appreciate. But yes, I'm not I'm sorry, Gen Z. I'm in my 40s. I am who I am. And I part right in the middle of my racing stripe and I love it. And it's not changing. So we are who we are. Katie said, I vividly remember that. I do too. A lot of us do. I am on the cusp. I am a Zennial. So I am at the very end of Gen X and the very beginning of the millennials. So I'm definitely hey, this is where I'm at. So the collective conscious of that time is where I'm at. Thank you so much, Michael. It's good to see you guys. I cannot believe I forgot to share this. I feel so silly for not sharing it, but I'm going to share it out to the Twitters real quick and let them know that we're live. Guess what, Twitters? We're live because because it's a chill stream and that's what we are doing. And then we will get to Twitter a little bit as we rule on the court of public opinion for last week because we had to go to a runoff, which I've never had to do before, but we had to go to a runoff. And that was really fun too, because you guys had very strong feelings about Batman. And here's what happened. So for those of you that have only seen part of last week's court of public opinion with my guest, Scott White, we talked about best Batmans and we had to go to a runoff. And here's what I didn't realize because I don't know all the things. I didn't realize that I was going to run out of options because there were so many people that have played Batman that I was going to run out of options on Twitter and on YouTube. So I was like, look, these are the Batmans we're doing. And then people are like, but what about Kevin Conroy? And I'm like, no, you're right. And then people are about, what about Val Kilmer? I'm like, I get it, but he got bounced out of round one. So we had to get down to a kind of bracketing system. And we went with 2 voice actors and 2 live actors, which we decided on Tuesday when we're like, these are too close. We have to just revote. 2 voice actors, 2 live actors. That's how we did it. I feel like the debate is going to rage on because there are aspects to the who's the best Batman debate. And this is the thing about the court of public opinion that's so valuable to me and what I love about interacting and having these debates with y'all. When we do court of public opinion, we get to nuance conversation on social media in a way that's not cancelable, in a way that's fun, in a way that's kind of cheeky. We get to nuance conversation of how do we determine the best Batman? Is it by best franchise? Is it by best actor? Is it by best performance? Is it by best looking? Is it by I'm sorry, George Clooney, you had nipples on your suit and we're done with you? Is it by who had the best dynamic with the villain in the movie? How does one decide what is best? And that's what's great about the court of public opinion is we get to have conversations about the fact that we don't all reason the same way and we don't all categorize things the same way. So we can't say, well, I think this is the best Batman because this is the Batman that I grew up with, or this is the Batman that was the Batman when I was a teen. And that's when I was really into this franchise. So this is the best Batman for me because this is my childhood memories. Or this is the Batman who I think looked best in the mask. Or this is the Batman who didn't have to put on a weird voice because a lot of y'all had feelings about the voice that Christian Bale chose. I get it. I also have a lot of questions about that choice as an actor, but I digress. So there's a lot of different ways to pick best. What do we mean by best? And that's why it's the court of public opinion, because the court of public opinion gets to say, our court believes that this is what is best, because there's no real right answer. It's the process of coming to a decision is the point of the court of public opinion. and we all get to learn about it. Barbara said, I'm much older and my widow peak is front and center and my hair is spiked. I love it. You don't have to worry about a part at all. You just get to do it. You just get to do it. Yes, you did catch a live. Hi, we're live. I have kombucha with a little bit of vodka. I was running late because I was trying to get things together. There's a lot of lawsuits to cover. So we should probably get started, but I really, really just wanted to chat for a minute because I'm like, it's nice to get to talk about the process, get to talk about why court of public opinion's important to me. And it's important to us because I think we've lost a lot of the ability to have a friendly debate in a really fun way. Everything has gotten so serious, and I get it. We are, as a, particularly in the States, as a society, tackling with really big issues and really big societal shifts. And those things are important, but also we're in the middle of a pandemic. Also, we have been off and on of lockdowns for a year, and also people are fatigued. So to be able to have fun conversation and lighthearted, fun debate is a really good thing. And I think a really healthy thing for all of us to remember. Look, we can disagree and still have fun with each other. And then when we get to the serious topics, we can take the things from court of public opinion and bring them to the serious topics with compassion, even when we disagree, because I really think that conversation is the only thing that's going to move us forward. And I really, really do believe that this community is changing the way that we have conversation on social media because I see it. And when I go onto social media, to share and to interact with y'all because y'all are the greatest community on the internet. And we have really real, but fun conversations. Celine, yes, ice cold Sierra Nevada double IPA. Get it. You guys are drinking mango kombucha this week, and my favorite has been peach pineapple. I get it. I have pineapple today. It feels very summery, very, very summery. Yes, Titan, that is the problem we are having with social media right now. It's gotten nasty. And the thing is, if we don't come at serious topics with compassion, we're going to end up at stalemates. And I've seen this I've seen this in court. I spent most of my career in a adversarial system where there are two sides and there are meant to be two sides to come to a middle. And without two sides, we're not going to come to a middle. But also when people can't say, I'm here and let's talk about why so we can come to a middle, I feel like we're not going to get anywhere. So it's healthy conversation. And I think the court of public opinion brings some of the fun back to social media without discounting the heaviness of some of the topics that are going on. So that's where we're at with court of public opinion. We will get to it later on in the evening, but I want to know from you guys, do you want to talk about Girardi first, or do you want to talk about Taylor Swift first? Let me know in the chat. Those on the replay can just hit the timestamps that tech helps me put together. Why is my arm off? Has my camera moved? Yes, it's probably me. I've bumped it. Hold on, we can wait. There. Ooh, there we go. I have two arms again. Woohoo! You guys are like, Taylor. Wow, Taylor is smashing. All right, Tay. Swift. Y'all are killing it. Okay, and before we're doing Taylor first. We're getting it. We're getting to Taylor first. Let me know in the chat if y'all are in Clubhouse, because I've talked about the fact that I've gotten sucked into the Clubhouse rabbit hole. Look, I know it's iOS only. I get it that it's being bougie. I know that it's invite only. I get it that it's being bougie. But if you're in Clubhouse, let me know in the chat or in the comments. I'm at the Emily D. Baker on Clubhouse if you want to follow me. I think I'm going to start hosting a few rooms, but I'm very interested in the Clubhouse competitor that's rolling out from Twitter. Cheyenne says it's almost like we are desensitized to real people issues. It is, and that's tragic, because when we become desensitized, we can't be compassionate to the plight of others, and then we can't make anything better. And if we can't make anything better, then things aren't better. And I don't like that at all. So compassionate ways forward. I appreciate the super chat. So if you guys are on Clubhouse, okay, I see a lot of what's Clubhouse in the chat. If you guys are on Clubhouse, it is a iOS invite only app that is audio. So it is a place for conversations. You can join rooms. The rooms have topics, they have moderators, and then you come into these spaces and have conversations. A lot of YouTube creators are on Clubhouse. So it is right now invite only, but I will see if I can see what I have on Clubhouse. A lot of creators are on Clubhouse. So I have been in rooms with all different kinds of YouTube creators, which has been really fun because I get to connect with other creators. I want to connect with you guys too. People are saying it's also on Android now. I didn't know that. That's fantastic. So here's the thing with Clubhouse though. Yes, it's invite only. Yes, it's been having a little bit of trouble. It's been struggling the same way that Pokemon Go struggled with server capacity when it was new. It does struggle with server capacity. And I really do enjoy Clubhouse. But Twitter is rolling out a Clubhouse competitor. And so I'm very interested for us law nerds if the Twitter competitor that is called Spaces, which is like I could open up a space and y'all could come in on Twitter and then we could all just talk to each other like a big old party line, but not like a hi, you've reached the party line. Not that kind of a party line, but like, hey guys, what's up? Instead of me just answering chat, it's voice. So yes, AOL chat rooms, but voice. So they're voice chat rooms. So when you open up, I'm just going to show you guys so you can see it. But when you open up Clubhouse, and this will tell you all the things you need to know about me, you'll see, well, everybody I follow on Clubhouse is creators. But when you go into Clubhouse, you will see, and of course it's blank, but you will see different rooms and then you can choose by topic what room you go into. Like Tiffany Haddish has a room going on right now. That's the one that came up first. And you can jump into the room and join the conversation. So that is Clubhouse. You can see where the people you're following are. But I think that the Twitter competitor might be really interesting because we can all just, everybody that's on Twitter wants, I'm hoping I have the ability to open spaces, but anybody has the ability to open spaces. Once we can open them, you can go in and then we can all chat. We can all chat. I am not touching on the new Depp Heard case docs tonight. It is on my list for Tuesday because I've been going through these documents. So it is on for Tuesday. Oh, fantastic, Eugene. Clubhouse is how you found my channel. See, I've been on Clubhouse a lot this week. It's a fun platform. It's a new social media platform. If you don't have time for a new social media platform, I get it. I'm interested to see how we all get to chat when spaces open up on Twitter because a lot of us are already there on Twitter. Yay for new Pokemon games over 12 months. I'm very excited about new Pokemon 2. Matt, very, very excited. So thank you. I appreciate that. A lot of you guys say that, so it's fun. No, not everybody talking at once. People kind of take turns. And on Clubhouse, it's fun. People take turns. So we'll see what happens with the different spaces. And I will keep you guys in the loop about where I am and when. And if you're on Clubhouse, just follow me on Clubhouse. You'll see when I'm live over there. But it's not ever going to be my main place for content because I don't want those of you that are like, I haven't been invited. I don't want a new social media platform. That feels like a lot to feel excluded. So I will be here first. I will be here first. Congratulations. It's so good. It's so good. I saw you on Clubhouse yesterday. I wanted to ping you up on stage, but didn't know. Oh, Shelly saves the day. You guys were great. I'm always welcome to be on stage. I talk for fucking ever. And you ladies are fantastic. I love the ladies' rooms that you have on Clubhouse. And I was just happy to be there. So yes, always yes. Happy. And I love the lady spaces on Clubhouse too, because you don't get like 9 of the bro dudes all answering the questions together, being like, hey, I'm a bro dude. Hey, I'm also a bro dude. Hey, I'm also a bro dude. All right, you guys wanted to get to Taylor. Let's get to Taylor. Because the media's got it wrong again. Shocked. Let's all be shocked. Let's all show our shocked faces together. Oh, the media's got it wrong again. So what I'm going to do, like I do on Tuesday, is that we are going to cover the topics both and then take questions. So if you guys want to make sure your questions get answered, y'all can chat about what you think about what I'm saying. But if you have a question and you want it to get answered, hold on till we're done at the end, because once we're done at the end, I will take questions. So let us get into Taylor Swift and the Evermore lawsuits. I love that so much. I love it so much. It's like we have transitions and stuff. Taylor Swift lawsuits. Guess what? There's more than one now. For a quick up to speed, Taylor Swift. You know who Taylor Swift is. I don't need to catch you up on who Taylor Swift is. Taylor Swift has a new album called Evermore. There is a LARPing, yes, live action role playing theme park in Utah called Evermore. Taylor Swift's album is called Evermore. Evermore theme park sued Taylor Swift and her rights management group et al. Over alleged trademark infringement. There was lots of good information in that lawsuit because they attached all the legal communications between the lawyers before the suit came to court, which was fascinating. There's a whole video. It breaks it all down. You can go check it out. I will link it below or card it or something. It will be there. Then in that case in Utah, the plaintiff in the Utah case, do you see what's happening? As I'm already saying the plaintiff in the Utah case, and my eyes twitching because there's now two lawsuits in two different places. The plaintiff in the Utah case filed a motion for preliminary injunction, which we're going to go over first. And then Taylor Swift's company, TAS Rights Management, who owns, who is the company that handles the business shit, they sued Evermore Park in Tennessee. So Taylor Swift's rights management group, TAS Rights Management, sued Evermore Park in a separate lawsuit in Tennessee. And all of the media is like, Taylor Swift countersues. I'm like, that's not what a countersuit is. Ugh, it's not hard. It's not hard. That's not what a countersuit is. Taylor Swift's rights company sued. It's not even a cross complaint. It's another lawsuit. It's in a different jurisdiction. It's in a different court. And I will explain what a countersuit is when we get into it. But first, we are going to get into this motion for preliminary injunction filed by Evermore Park. Like Evermore Park's like, we're not even waiting. We're moving forward. We filed the complaint. There's an extension of time to file the answer, but they want to go now. They want to go now. I want it now. I want it now. I want it all. Okay, that's where they're at. They want to move forward now, and they want a preliminary injunction. A preliminary injunction is a, hey, Your Honor, stop them from doing shit I don't want them doing. Your Honor, make them stop it. Stop it. Stop. Collaborate and listen. ICE is back with a brand new invention. Something. Grab a hold of me tightly. Okay. I'm going to stop. No, I'm not. Stop in the name. Damn it. Look, we're going to work through all of the stop songs in this one because it's a preliminary injunction. And a preliminary injunction is like, stop this shit. Because while the case is pending, if you continue to do this shit, it continues to damage us. So if you don't stop it while the case is pending, then it's going to be problematic. So let's talk about the preliminary injunction. Stop. Collaborate and damn it. I'm going to get through all of the stops. Stop. Wait a minute. Fill my glass, put some liquor in it. Okay. Let's go. Relief requested pursuant to Federal Rule of Civil Procedure 65. That's what this is. We're in federal court in Utah. We're going to hear about the federal rules of procedure. We're basically doing Civ Pro here on the YouTubes and on Friday Night Live on the Facebooks as well. We're basically doing civil procedure. I think I'm more fun than most Civ Pro teachers. I don't know. It's been a long time since I've been in law school. My Civ Pro teacher was not nearly as fun. Okay. Plaintiff respectfully seeks a preliminary injunction stopping, that's what enjoining means, stopping defendants from using Evermore trademark. 1, in connection with the specific items of apparel covered by the U.S. trademark registration, dragon eggs. And 2, in connection with the live entertainment services covered by U.S. trademark registration. That one. Preliminary statement. Oh God, this is a rehashing of the lawsuit. So I'm going to go through this quickly because this is a rehashing of the lawsuit. Evermore has invested $37 million in the creation and promotion of Evermore Park and the Evermore trademark. This investment includes nearly $1 million spent in advertising expenditures, direct labor costs for advertising, and acquisition of the domain name evermore.com. Yeah, they spent like $40,000 or something to get the evermore.com, but that has literally nothing to do with Taylor Swift's album, but okay. Also, if you want to hear me rant about their marketing expenditures and the ROI on those, you're going to have to go to the other video because they talk about how many people had visited the park and how much money they've spent. And it's like, what? So, to cite one example, a video about Evermore Park created by BuzzFeed's Bring Me amassed 25 million views. I challenge. We're gonna link it. I want to see, and has generated 65,000 comments. Okay, wait. It's on Facebook. Yeah. Oh, I know. It's on. Are we counting Facebook views? Are we counting Facebook views? I guess we're counting Facebook views. Where does it show the views? I want to know. Where does it show me the views? I see 65,000 comments. I saw this on YouTube. I don't see the views. I don't. If I expand it, will it show? No, I don't want to hear you. 25 million views. Okay. There we go. This video has 25 million views. Fair enough. But that's also a BuzzFeed video that is 3 minutes long? And I wonder if they ran advertising to it. Do you think that Evermore Park ran advertising to this video and then bumped the numbers? Because they didn't mention these numbers in the lawsuit. I'm curious. Anyway, prior to defendant's announcement of the Evermore album, the final result of a Google search for the term Evermore pointed to evermore.com, and subsequent results, that it's not fucking relevant what your Google ranking is as to whether your trademark is being harmed. This, my eye caught this. But true. But Google search ranks aren't the determining factor. Like, there's no law that says Google search ranking is how we determine that your trademark rights are being infringed upon. Like, that's not how that works. But okay. Despite Evermore's well-known rights in the Evermore trademark, defendants adopted the Evermore trademark on December 10th, 2020 in connection with the release of defendant's album. Cool. This is what we've said all through the lawsuit. Efforts to contain the COVID-19 pandemic have been crippling for businesses like Evermore. That I am deeply empathetic to and feel badly for. But again, that's not Tay-Tay's problem. Also, I would imagine if we pulled up what Taylor Swift's business was supposed to look like in 2020 and what it actually looked like in 2020, there would be a vast difference because there's like tours and shit that she would have been doing, probably contracts that she lost money on because she wasn't able to tour and had already paid and booked those venues. And a lot of the clauses, a lot of the acts of God clauses in contracts didn't include, pandemic. So I'm sure Taylor's business has also suffered because of COVID-19, but okay. I am empathetic to that, but again, not Taylor's problem, not a problem for your trademark. The pandemic has put Evermore into a struggle for survival, yes, and Taylor Swift's side says that that's why you're suing. A fact that defendants know well and are deliberately exploiting. Huh? Okay. Defendants' public responses to this lawsuit focus on Evermore's financial duress no, that's not what that said. Their public responses said that you have other lawsuits, Evermore, and that those other lawsuits might be the impetus to this lawsuit because you're being sued by a lot of other contractors, they allege, that haven't been paid according to those lawsuits. Again, lawsuits are alleged. Defendants' public responses to this lawsuit focus on the financial duress. challenge. Defendants have made clear that they intend to prey on Evermore's financial duress to misappropriate the Evermore trademark. Ugh. Repeatedly emphasizing that Evermore can ill afford protracted litigation with one of the world's wealthiest entertainers. No one can. No one can. No one. Most businesses can't afford protracted litigation. It's something that we talk about a lot. Protracted litigation is bad for everyone. And it was said in the cease and desist letters, which I cover, it was said in the cease and desist letters that, hey, our marks are separate and this is why. There are other trademarks in this same category. Our album and your LARPing park aren't going to be confused by the consumer. Remember that the point of trademarks is to identify the source of a good or a thing to the consumer. So one of the big questions is the consumer going to be confused? Is someone going to buy Taylor Swift's Evermore album and think they were buying a ticket to a theme park? Is someone going to go to a theme park and think it is connected somehow with Taylor Swift? Okay. We're moving on. While defendants enjoy their place at the top of the music charts and the attendant revenue, Evermore is left struggling to maintain relevance in the face of a deluge of information related to defendants' misappropriation of the Evermore trademark. Again, it's very interesting how they categorize that, because I feel like a lot of us know who the fuck they are because of this lawsuit. Yes, it might not be ideal publicity, but it's still publicity. I just, again, none of this is relevant to, well, okay, maybe they're going to make it relevant to their injunction. We'll be kind. Let's see. They're mad. This is big mad. While defendants, it's sassy though. I do appreciate a sassy sentence. While defendants enjoy their place at the top of the music charts and the attendant revenue, Evermore is left struggling to maintain relevance. I don't know if they're struggling to maintain relevance or if they're struggling because of COVID restrictions, which seems like the most likely thing, because I can't guarantee. I bet you if COVID weren't happening and this lawsuit brought this park to all of our awareness, we'd be like, can we go LARP, please? Can we go like be elves and like drink grog together? Can we have a field trip? Like, I want to go. It would be fantastic. Okay. So I don't know. The struggling to maintain relevance. I get that that's what they want to say. It is that they're seeking an injunction, but I just don't know how true that is. It's their perception. It's my opinion, but it's a lawsuit. Evermore seeks a narrow injunction covering only the specific goods and services recited in U.S. trademark registrations. Evermore recognizes that a preliminary injunction is an extraordinary remedy. True. It's drastic. And any relief should be narrowly tailored, not tailored, but tailored. Anyway, to mitigate against irreparable harm while the litigation proceeds. They are trying to stop Tay-Tay from doing the shit that they don't want her to do while litigation proceeds. Here's the strategic part of this. The strategic part of this is that if there is a preliminary injunction stopping Taylor from doing stuff, then it puts a different type of litigation pressure on Taylor Swift's side, a type of pressure that this park is experiencing, in my opinion, because of COVID. Because again, if it weren't COVID, wouldn't we all be like, can we go check this out, please? I'm fascinated. Let's go play and have adult play. But because of COVID, you can't. And I get that. But they're feeling a different kind of litigation pressure, not because, in my opinion, of what Taylor Swift's side is doing, though that might change when we get to the next lawsuit, but they're feeling pressure because of COVID. They are trying to equate that pressure by then saying, okay, well, if Taylor can't continue to sell her album or her merch, she is also going to feel financial pressure, and the injunction will do that. Evermore is entitled to this narrow relief. In the absence of such relief, Evermore will suffer irreparable harm to its reputation and may be forced to close its doors permanently. Again, at some point, it will be interesting to see how much of that can they attribute to Swift's album, and how much of that is going to be attributed to relatively low attendance before this based on the numbers that they reported. And I say relatively low attendance, for me, juxtaposed to their marketing budget based on the numbers they put out in their last lawsuit and a year of COVID. So that's what that is. Evermore's trademark rights. We went through this in the last video. These are name marks, which means the word Evermore with regard to coats, dresses, hats, the name Evermore with regard to entertainment services in the nature of live, visual, and audio performances by an actor. The registrations are prima facie evidence. We know that the registrations are valid. Evermore expanded $400,000 in advertising and promotion. Oh, that's right. It was $300,000. They spent this keeps screwing up, so I'm going to try to do it better so it doesn't keep doing that. They spent $300,000 to buy the domain name evermore.com, which again has literally nothing to do with Taylor Swift. That was their choice. Like, why couldn't they have purchased evermorepark.com? They chose to spend $300,000. Again, not Tay-Tay's problem, but they're trying to show that they have actively defended their trademark, showing that this is a reasonable injunction because they are trying to prove that they are actively defending this mark. Oh, here we go. Here are the guests. Ha! They brought it up here too. Thank you, Evermore lawyers, for making it easy for me to make my points because you put all the same information in here. Since opening its doors in 2018 to date, Evermore Park has provided entertainment to 142,000 guests. Now, there is no shade in this. That is a lot of people. But they have spent $400,000 on advertising and $300,000 to get the website. So what is that? $800,000, almost $1 million to bring in 100,000 people. The ROI on that is probably part of why this is struggling, not necessarily the Swift album. How much is that? And this, this is since 2018. So really 2018, 2019. So over 2 years. Does somebody want to break down divide 800,000 by the 142? Because how much are they spending to get each one of those 142,000 guests? Because that's a lot. Like $800,000 to bring in 142,000 people is not an ROI that I like. And I struggle. These are the Evermore merch items that they are dealing with. Thank you. That's a lot. So this is the Evermore merch. At some point, this is all in the complaint. This is already off of the website, the Evermore merch. None of this merch that they're going to show, except for one thing, says Evermore. And it looks like the other Evermore stuff is already off the website. This is Visit Utah. On social media, direct association between Taylor Swift and Evermore Park, though we've seen that Evermore's also used that. The first is #Evermore, the new Taylor Swift album. The second is Evermore Park, the immersive storytelling theme park in Pleasant Grove, Utah. Know the difference. Okay, Visit Utah. Is Visit Utah trying to be sassy? Is it a sassy tweet? Is it a fun tweet? Were they just trying to ride the #Evermore trend? I have questions. Legal standard: party seeking a preliminary injunction must satisfy a 4-factor test. The requesting party must demonstrate, 1, that it has a substantial likelihood of prevailing on the merits. I don't know if they're going to be able to show that. 2, that it will suffer irreparable harm unless its preliminary injunction is issued. And I think that COVID is going to play against them here, because a lot of the harm I think the court will say that they're suffering is not because of Taylor Swift, but is very much because of COVID. 3, that and winter. Like, I don't think they're open. I think they're a seasonal park. So they've also been closed because of winter. That threatened injury outweighs the harm the preliminary injunction might cause the opposing party, that the preliminary injunction, if issued, will not adversely affect the public interest. Okay, that's probably easily met. I don't think the public interest, well, I don't know. You tell me, will the public interest be affected if Evermore is not available to purchase or to stream? Some might say yes. Oh, this is a very short sentence, a very short paragraph. This is a very short paragraph. Plaintiff has sued defendants for trademark infringement under the Latham Act. Right. And is likely to succeed on these claims. I don't know about that, because I feel like we need more information here. They own a valid protectable mark. I agree. That defendant used the trademark in commerce without plaintiff's consent. Disagree. That defendant's use of trademark creates a likelihood of confusion. Strong disagree. Still, despite the other required elements, the central inquiry in a trademark infringement case is the likelihood of consumer confusion. Yes. And I don't think this factor goes in favor of Evermore Park. I don't think there's a substantial likelihood of confusion between Evermore Park and Taylor Swift's album. I just don't. I'm not confused, Utah. I'm not confused by the difference here. I'm not. I don't think most reasonable consumers would be. But I digress. Defendants have used Evermore trademark without Evermore's consent. Agreed, but only kind of, because I think that the way Evermore, the album, is using it is not necessarily the way that Evermore the park was using it. I think there's actually the legal beef of this is with what's being used and how the trademarks are intended. I think that we're just weighing it. We're weighing it down. I think that the factor 1 goes to Evermore Park. They own a valid mark. Yes. Evermore Park. 2, the defendant used the trademark in commerce without plaintiff's consent. That, I think, is the most interesting conversation for the court, because I think the way Taylor Swift is using it is not the way that Evermore Park has it registered or intended to use it. I don't think there's crossover there. So I think that is an issue where the court has some teeth of hey, that's something we need to weigh out on both sides. There's interesting arguments to be made there. But 3, the defendant's use of the trademark creates a likelihood of confusion, I think goes to Taylor Swift. I don't think there's a likelihood of confusion. And at the end of the day, if these top 2 things are true and this third thing's not true, Evermore Park can't win, because the likelihood of confusion is the whole fucking point of trademarks. Instead of going over the complaint, because this goes over the complaint, let's get to their prayer for relief and see what they're saying. They're talking about Taylor Swift's. Hey, we're talking about YouTube again. Yay, YouTube just is coming up in everything we talk about. They're talking about how many views Taylor Swift's Folklore album has on YouTube, which again, they're probably trying to make the correlation, but I don't think is really relevant here. Miss Swift announced a tour to promote her Lover album in 2020, but the performances were canceled due to COVID-19. Right. Miss Swift will offer live entertainment performances under the Evermore trademark. We don't know that, because if the Lover tour was canceled, it might be a Lover Folklore Evermore. But if she doesn't call it the Evermore tour, can she still do it? Yes. Yes, she can. So let's continue on. Defendants' actions are more likely to cause and have already caused confusion in the marketplace. We went through this when I talked about the complaint. I don't think there's a high likelihood of confusion. I would love to hear your thoughts. I don't think people are going to accidentally go to a theme park and be like, wait, this isn't a Taylor Swift concert? I'm so confused. I just don't think that's likely to happen. I really don't. Defendant, this is all in the complaint. All of this we've gone over. There's evidence of actual confusion. No. There's evidence of increased web traffic for people looking for the Evermore album. And the fact that their bounce rate was so high mean people went to the website, went, oh, this isn't Taylor Swift, and left. I think their argument, each time they argue this here, that the web traffic to evermore.com shows that Taylor Swift fans were confused. I actually think it shows the exact opposite, because it shows a very high bounce rate, meaning that people went to evermore.com and went, oh, this isn't what I'm looking for. And then they bounced. Oh, they bounced. So it shows that they weren't confused because they came to the website and went, this isn't what I'm looking for. And then they left. I just think it doesn't prove their point. I think it actually proves Taylor's argument, or likely argument, in this case. The goods and services are identical. I disagree for most of the things. The theme park and the album aren't the same. Sweatshirts are the same, but Taylor's sweatshirts, if there is a sweatshirt that says Evermore from Taylor, I think there's an argument with regard to that item. But with regard to a sweatshirt with Taylor Swift's head with her hair braided and the park having a sweatshirt that says Evermore, I don't think there's a likelihood I don't think there is. And this was all in the complaint as well. The Evermore trademark is strong. Taylor Swift's team is arguing that it's not in those letters. Where is the point? Can we get to the point? The threat and injury to plaintiff outweighs any harm. When evaluating the balance of harms, courts consider whether the harm to defendant might suffer is self-inflicted or avoidable. Oh, I need to look up this case. I'm very curious as to what the badass coffee case is. I want to know. That's going on the list. Badass coffee. 636 F subsecond at 1251. I need to know. Indeed, when a party knowingly takes actions that increase the potential for harm, and if an injunction is ordered against them, courts give those harms little weight in the balancing test. Evermore stands to suffer great harm if defendants are permitted to continue offering goods and begin offering live entertainment under the Evermore trademark. Again, I don't know why they couldn't just resolve this and be like, hey, is Taylor going to name her tour Evermore? No? Okay, cool. It just, I don't know if this, I get why they filed it. I just don't know if it's actually needed, but we'll see. The parties clearly aren't getting along very well. For the foregoing reason, Evermore respectfully requests that this court grant its request for a preliminary injunction and enjoin defendants from using the Evermore trademark to promote or sell clothing and live entertainment services. So they're trying to block a tour called Evermore, and they're trying to block her from selling merch. The thing that's so telling to me in this entire injunction is A, it's speculative. She hasn't announced a tour, and so it's not really ripe yet. But B, they have posted no merch that competes. Titling a collection on a website, Evermore, that's A, already down, and B, that's not the problem. They're not actually selling anything called Evermore. So this sweatshirt is not conflicting with these items. It's just not. So the fact that this is their best example is this sweatshirt shows me that this injunction is likely to not be granted, particularly with regard to the clothing items. Whether the court will say, okay, don't announce a tour named Evermore. Maybe the court would say that. Like, if you're going to announce a tour, you don't use the Evermore name until this is resolved. I'm sure Taylor will call it something else because there's now 3 albums that she can tour on. It'll okay. Okay. Sure. It'll be interesting to see what the court does with this injunction. The court also gave additional time by stipulation for Taylor Swift's side to answer this lawsuit. So this lawsuit hasn't been answered yet. Do you know how it was answered? Let me tell you how it was answered. It was answered when Taylor Swift's side filed their own lawsuit in Tennessee. So let's hop over to the Tennessee lawsuit, not a countersuit, because a countersuit is like, I sue I sue someone for defamation, And then they say, no, you defamed me and I'm going to sue you within the same lawsuit. And we're going to go, ah. Like the Keemstar lawsuit. Romeo Lacoste said, I'm suing you for interference with business. And Keemstar went, I'm going to essentially countersue you in the same lawsuit, sue you within the same lawsuit for using the court process to silence me. So a slap motion. You are using the court to silence me. You don't have a case, so I'm going to sue you within the lawsuit. That's not what's happening here. This is a whole ass grown separate lawsuit in the state of Tennessee. Let's jump in to TAS Rights Management suing Evermore Park LLC. Yay! So, TAS Rights Management LLC, Taylor Swift's company, is suing Evermore Park LLC and Ken Brett Schneider, the owner of Evermore Park, for a whole bunch of shit in the District Court of Middle Tennessee. Let's just have a chat about what Taylor Swift is saying that Evermore's been up to. Plaintiff is the undisputed plaintiff. Now is Taylor Swift in this case. See, if it was a cross complaint, it would be cross claimant or cross complaint. I think they're using countersue in the non-technical phrase, but again, Taylor Swift also sues them. It's maybe a retaliatory suit. I don't think it's actual retaliation. I think it's, hey, this is what this is. This is what this is. This is riling the lawyers. Hey, Evermore Park, you wanted us to pay closer attention to you. You now have our attention. Oh, we have some issues. Let's have a chat. Summary of the action. Plaintiff is the undisputed beneficial owner of registered copyrights, not trademarks, copyrights in the original songs, including all public performances thereof, Love Story, You Belong With Me, and Bad Blood. Because baby, now we got bad blood. You know, it used to be mad love. Okay, Emily, stop. You cannot sing. You do not sing well. Do not make the people listen to you sing. Broadcast Music Inc., BMI, a performing rights organization, PRO, protects the works as well as the compositions of over 1 million other artists around the world. BMI was created to protect and enforce the federally granted public performance rights of those songwriters, composers, and music publishers by collecting federally mandated license fees for use of their art. Do we see the direction this is going in? Do we? Let me know in the chat if you see it. Indeed, the rights and revenues protected by BMI and other PROs are a central pillar of the music industry and are enforced. How the fuck is that a pronunciation? Enforced around the world with millions of law-abiding establishments. Oh, boo. Oh, dear. This process is based on the fundamental principle that artists should be compensated for their work, and countless creators around the globe depend on honest compliance with the system. You cannot use copyrighted music in a commercial establishment without licensing fees. See, that's not how that works. That's just not how that works. Ask any Twitch streamer if they're now aware of how it works when you play copyrighted music. Ask any YouTuber who's had the radio on in their car while they're vlogging. You can't. The reason you can't download an Instagram reel with the music is because Instagram as a platform has agreements with BMI. And TikTok has agreements. So licensing fees get paid from the platforms, which is why you can use music to do like whatever it is we do on the TikTok. That's why licensing fees are paid. Yes, girl. That. accounting for instances where the foregoing system would be flouted or outright ignored by entities seeking to profit from music without compensating creators, Congress provided for a federal infringement claim to compensate creators and, critically, to discourage infringement. Bad. The enforcement mechanism remains a fundamental element of the legal protections afforded to artists. Without it, any entity could willfully deny compensation to artists for years and then paper over its unlawful conduct with an email after the fact, as defendants attempt to do here. Oh my. Oh my. This is why restaurants pay for a music service if they're going to have music in their restaurants. They pay for a music service so that that music can be on and it's paying proper royalties. Okay. Okay. In this case, representatives of plaintiff were recently informed that the works, among many other copyrighted compositions, had been routinely used by defendants Evermore Park without authorization or license agreement at defendant's theme park called Evermore Park. This is absolutely don't rile the lawyers, because now they're like, oh, you wanted our attention. Adorable. Defendants had and have a statutory obligation to properly license any music compositions publicly performed or otherwise used in their theme park. Starting in 2019, throughout phone calls, emails, letters, and draft license agreements, BMI repeatedly informed defendants both of the copyrighted nature of the works and of the unlawful nature of their continued use of the same in public performances at defendants' theme park. Ruh-roh. Defendants ignored these messages, opting instead to continue using the works without authorization with full knowledge of their infringement. Well, if BMI reached out, there's probably evidence that they've done it to drive attention and attendance to their theme park. Evermore Park employees play songs upon request in addition to the copyrighted works at issue. In this action, plaintiff has also been made aware of Evermore Park performers playing songs by Katy Perry, ABBA, The Beatles, Billy Joel, Britney Spears, Green Day, Gautier. I was like, how, what? I imagine it's just the one Gautier song, but okay. Journey, Nirvana, Semisonic, pulling out some of the oldies. Third Eye Blind, Tom Petty, Queen, Weezer, and Whitney Houston, among others. That sounds like a good playlist. But also, yeah, you can't do that. Accordingly, plaintiffs bring this action to recover damages and to enjoin defendants from continued infringement, which means stop it. Stop it. Stop it. You can't perform a licensed work at your park. Plaintiff Tass Right Management LLC is a Tennessee LLC with its principal place of business in Nashville. Tass is the legal owner of exclusive rights in the copyrighted works. Tass manages and regularly represents the intellectual property interests of singer-songwriter Taylor Swift. Non-party artist is a resident of Tennessee. Defendant Evermore LLC is a Delaware limited liability company. It's the park. Non-party, meaning not in the lawsuit. Broadcast Music Inc. is a PRO that serves as a central licensing authority and protector of the public performance rights afforded to composition rights holders under the United States Copyright Act. BMI represents songwriters, composers, and music publishers. Okay, we know enough about BMI. Jurisdiction and venue. Jurisdiction. This action arises under the Copyright Act. The court has subject matter jurisdiction. Defendants are subject to personal jurisdiction in Tennessee. Why? Why are they subject to personal jurisdiction? I'm very curious. Because, among other things, defendants knew that artists reside in Tennessee and their willful infringement of her works would cause, and in fact caused, harm in Tennessee through, inter alia, loss of valuable licensing revenue due and payable through BMI in Tennessee. Doesn't that sound an awful lot like because Toddy Westbrook lives in Washington and defendant knew that she lived in Washington when she made said statements on Twitter and YouTube? It sounds like the same argument about jurisdiction to me. Defendants' knowledge that Tennessee is the locus. I love that. It's the nebula, the center, the nebulous of the conduct at issue. in this action, having recently reached out to BMI's Nashville, Tennessee office multiple times. Oh my. Whoomp, there it is. This is what happens when I first look. You get all of the live reactions. Having recently reached out to BMI's Nashville, Tennessee office multiple times, suddenly requesting retroactive license for the works after first repeatedly infringing the works and ignoring BMI's numerous license requests. Indeed, defendants initiated contact only after recent events made this action imminent. What they are alleging is that Evermore Park has been going to BMI saying, retroactive license, please fix it. Please fix it. We don't want to be sued. Please fix it. But I wonder what the recent events are. I bet we're going to find out together. Prior to this recent retroactive license request, as noted above, defendants repeatedly received phone calls and written requests from BMI of defendants' willful copyright infringement. So BMI's been like, hello? You're using our shit. We would like you to pay us now. And Evermore was like, yeah, nah, we're not going to do that. And then something went down. Something went down. Here's what I think went down. Okay, before we get to it, here's what I think went down. I think Taylor's lawyers at some point when they were conference calling over all this shit were like, do you really want to do this? You also know that you've been singing our music at your park or playing our music at your park, and BMI has been coming after you for licensing. Are you sure that you don't want to just deal with this? You really want to sue us? Really? Really? Okay, then. Lawyers still got to work. Through written communications, please God, let them be attached. Through written communications sent to plaintiffs' representatives in Tennessee, defendants have attempted to engage with plaintiff and artist and force a settlement of a meritless trademark claim based on artist's December 2020 release of the Evermore album. Defendants conduct substantial business in this district, including the sales of music, film, tickets, and tickets for live performances at Evermore. So they're saying people from Tennessee go to Utah to go to Evermore, so they sell tickets in Tennessee, so therefore they do business with Tennessee. Therefore, there's jurisdiction over them. Defendants operate an interactive website. It's actually a fair point. Defendants offer for sale. I don't know if it's enough, but it's a fair point. Defendants offer for sale and on information and belief have in fact sold tickets to Evermore Park to Tennessee citizens. I mean, there's got to be one. There's got to be one. Defendant Brett Schneider has engaged in significant commercial activities in Tennessee, including owning and registering several companies that provide security for websites and produce movies and music that are sold and marketed in Tennessee. That's interesting. Venue is proper. Okay. The copyrighted works at issue. Artist is a world-renowned singer-songwriter. Cool. She has spent substantial time and energy, indeed her entire career, creating music that resonates with consumers across generations around the world. She has used her experience, talent, and creativity over years of hard work and the creation of 9 studio albums to solidify herself as one of the most recognizable names and brands in the music industry. I mean, do you guys agree? I don't take issue with that. I'm like, fair. With some of the most beloved and in-demand songs in the world. I mean, okay, fair. Plaintiff is the owner of exclusive rights for Love Story, You Belong With Me, and Bad Blood. The works are registered with registered copyrights, registered copyright information, all conditions precedent. Yeah. Legally legal, like she owns it. Yeah. Infringement by defendants. This is the T. Here's the T. What did Evermore Park do? What are they alleged to have done? Defendants own and operate an immersive experience theme park called Evermore, which just, it does sound cool. Like it does. It sounds like fun. However, all of this. Evermore Park opened in September 2018. Defendants employ actors who perform as various characters at Evermore Park. These performers interact with guests and publicly perform copyrighted songs on a regular basis. I have not been to the park. Has anyone been to the park? If you've been to the park, is that true? Does that happen? Let me know in the chat or the comments. At a section of Evermore's park known as The Burrows, 2 actors regularly and routinely perform copyrighted songs, including the works at issue in this action, to large crowds of patrons at Evermore Park. These unlawful music performances are marketed as a central attraction of Evermore Park. For instance, Evermore Park's website advertises that visitors can create fanciful music with park actors and describes one of the park's main activities as musical character performances. Okay, right, but does that mean copyrighted works? Like, I don't think that alone means copyrighted works. Defendant Brett Schneider controls and directs the operations of the park, including the performance of copyrighted songs. Indeed, the idea and basis for Evermore Park began as a Halloween event that took place at Brett Schneider's home. Evermore Park has been described as the culmination of a lifelong dream. Yes, that was described um in the lawsuit multiple times, that this was a lifelong dream, that this was a childhood dream, this was escapism, and this was wonderful, and this is all the things. On numerous occasions, defendant Brett Schneider attended the musical character performances at Evermore Park and actively encouraged the performance of copyrighted songs without license or authority. I wonder what evidence they have of that. Like, are there videos? I'm very curious as to what evidence they have that he was there being like, no, sing We Are the Champions. Like, I want to know how they know. I want to know the evidence. Defendants have never been licensed or authorized to use the works. I would imagine that's accurate. Defendants have used and have publicly performed the copyrighted works on numerous occasions. I'm interested to see again what their evidence is of that, other than BMI reaching out. I hope that's attached. Plaintiffs never gave defendants permission. Sure. Each infringing use or public performance of the work constitutes a separate act. That's true, of infringement and a separate claim against defendant under the Copyright Act. That means if this went on daily for a year, there are potentially 365. This means if shows that they can prove these songs were performed 5 times daily, 6 times daily for 5 days a week for a year, then it's each one of those performances counts as one. You can see how these things can tally up quickly. Willful infringement by defendants. For years, defendants have made clear and actual notice that their performances of the works and other copyrighted music constitutes copyright infringements. Defendants have been alerted on multiple occasions by the Nashville, Tennessee office of BMI. The defendants require a license to play the copyrighted works of artists and others, and that until such license is granted, defendants' conduct violates federal copyright law. On August 23rd, 2019, BMI's Nashville office sent a letter to defendants following up on a number of prior contact attempts, alerting them once again of their unauthorized performance of the works and their legal obligation to obtain licenses for the performance of the works. Yikes. Defendants were clearly and unambiguously informed that as the, quote, proprietor of a business where music is publicly performed, you are required to obtain authorization from the copyright owners of that music in order for your performances to be legal. A copy of this letter is attached here too. Included with the August 23rd, 2019 letter is a draft music licensing agreement provided to defendants. On September 18th, 2019, BMI's Nashville office sent another letter to defendants noting that, quote, BMI has been contacting you for some time regarding the necessity of signing a BMI music license for your organizations. In correspondence and phone calls directed to you on numerous occasions, the need for such license was clearly stated. A copy of this letter is attached here too as part of Exhibit B. But I got 2 Exhibit A's. Okay, we'll go hunting for Exhibit B next. The September 18th letter also alerted defendants to the seriousness of copyright infringement. Very serious. Ask YouTube. Ask Twitch, moreover. Included with the September 18th letter was a draft musical license. Okay, they provided it. Fine. BMI represents millions of songwriters. Fine. Defendant had actual knowledge that the works were protected. Yes, BMI reached out to them multiple times. If that's true, then they knew. Defendants blatantly ignored numerous notices from BMI and opted instead to continue to benefit from the free and unauthorized public performances of the work despite actual knowledge. And actual knowledge is something that will have to be proved. And it will be like, Your Honor, we have letters. There's letters. And the letters show that they knew. By failing to execute the license agreement provided by BMI and continuing to unlawfully perform the works, defendants acted with knowledge that their actions constituted copyright infringement. Recently, years after BMI began informing defendants of their infringing actions, when the filing of this action became imminent and known to defendants, and in an attempt to cover up their willful infringement, defendant Brett Schneider, on behalf of Evermore, called the Nashville, Tennessee office of BMI seeking a retroactive license that would cover all public performances from 2018, 2019, 2020, and 2021. Defendant Brett Schneider also sent an email to the Nashville, Tennessee office of BMI further requesting a retroactive license. Specifically, more contact. Specifically, plaintiff's counsel was contacted on February 3rd, 2021 by a former Evermore Park volunteer and frequent patron of Evermore Park. Look, y'all. This lawsuit has its own Lorianne. Here she is. Well, I assume. Here they are. A former Evermore Park volunteer and frequent patron of the park. Tell Cersei it was me! Advertising of the unlicensed public performance of artist music information was provided by this individual, proving defendant's infringement of copyrighted works. Oh, mother of God, it sounds like there are videos. Yep. Proving defendant's infringement of copyrighted works. I'm sure there's videos. I'm sure there's people who videoed being at the park. Defendants became aware of this volunteer's outreach and only then attempted within the past weeks to retroactively paper over their longstanding and willful infringement of the works. This is so fucking messy, you guys. Yay. In short, defendants are making a thinly veiled attempt to fabricate a record to justify and retroactively authorize their intentional infringement that has gone unabated since Evermore Park opened in 2018. However, a cover-up attempt now does not and cannot erase years of willful and knowing infringement. I will say, though, that BMI does sometimes grant retroactive licenses, but the time to do that was during all the times BMI reached out. It's like the time to respond to a cease and desist is like before they're like, fuck it, we're not sending you any more cease and desist, we're going to sue you. The time to respond to BMI is before it escalates into a lawsuit, and maybe before you choose to sue one of the singers whose works you have been using. I mean, maybe respond to BMI before you file that other lawsuit, knowing that you've shaken the hornet's nest of fucking lawyers. Yikes. Through the communications outlined above, defendants have acknowledged and admitted their intentional infringement of the works and the requirement for authorization in the form of written license agreement. Okay, but the court may well say, yeah, but you can grant them a retroactive license and they can just pay. Why can't we just pay? That it's possible. Count one, copyright infringement. Yes. Taylor Swift owns the works. I wonder if the label will join this. That would be interesting if Taylor's label joined and was like, yeah, and we own the other works that you've been using, so we're joining as a party. We've gone through those facts. Defendants willfully infringed plaintiffs' registered copyrights. Defendants infringed on copyrights by repeatedly performing them. Defendants received phone calls from BMI. This was all mentioned above. Defendants knew or recklessly disregarded. That's all mentioned above. Vicarious copyright infringement. Plaintiff repeats and incorporates what's above. This is a claim against defendant Brett Schneider individually for various vicarious copyright infringement, meaning he owns the park did the thing, he then benefits from the park doing the thing. So vicarious liability. Plaintiffs did not authorize it. This is all argued above. Defendants knew. That's argued above. Let's get to the attachments. Plaintiff is entitled to recover damages. Prayer for relief. Wherefore art thou, money, from performing these songs? I know, it's cringe. I get it. Wherefore plaintiff respectfully requests judgment against defendants Evermore Park jointly and severally as follows. that the court enter judgment against defendants, that they have willfully infringed plaintiffs' rights, that the court issue injunctive relief. Stop it. Injunctive relief. Stop. Stop. In the name of love. Stop. Wait a minute. Fill my glass. Put some liquor in it. Stop. Hammer time. Dun, 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 dun. Yeah. Stop right there. Thank you very much. Wow, we had a montage. Peter Mon would be proud. Peter, it's a montage. Beast. Okay, going on. That the court orders defendants to pay plaintiffs actual damages and defendants' profits attributable to the infringement, or in the alternative, at plaintiff's election. If I were the court on these cases, I'd be like, y'all go sit in a room and figure this shit out. Stop it. All of you. Go sit down and talk to each other. Certificate of service. Okay, let's pull up a few of these. And then, because I have been talking for an hour and 15 minutes, I am going to hustle through the Girardi updates and then answer your questions, because we have been here for a hot minute. Let me pull up those exhibits. See, when this downloaded, I got 2 of Exhibit A and none of Exhibit B. Damn it. I'm going to have to go back to Pacer and grab Exhibit B. Okay, let's do Exhibit A first, then. I don't need 2 Exhibit A's. 8/23/2019. Manager, Evermore Park. Dear owner manager, do you know how music licensing affects businesses and organizations that play music? We've attempted to contact you and explain how BMI works. You're playing BMI music. Did you know that you're playing our music? You can't do that. If you are playing music, this is interesting. If you are playing music, please license online or sign and return the enclosed licensing agreement as soon as possible. Notice regarding Utah Music Licensing Practices Act. Here are the rules. We think you aren't doing this. And you could just go ahead and sign this. Music licensing for amusement and theme parks. Amusement and theme parks has their own licensing agreement. You know why? Because this shit comes up. Unless you're Disney, who just owns their own music. Oh, I guess Universal does too. Universal's like, yeah, we own our own music. Everyone else has to play by these rules. Here's the agreement. You can just sign it. Here's the indemnity. Here's the payment provisions. Here's the breach. There's the arbitration clause. There's the reporting clause. Here's what we think you should pay for amusement parks with general admission charge. Is total attendance rounded down to the last 1,000 was 300,000 and divided by 1,000 equals 300. When multiplied by attendance, it's literally results an estimated general admission fee of $1,000. How much are they asking for in licensing fees? The total estimated annual fee for the first calendar year of this agreement is $1,700. Shut the fuck up. Shut the fuck up. Shut up. They are fighting over under $2,000. What? BMI was asking for $1,700 to license this for a year. What? Because it's going to cost more than $1,700 to respond to this lawsuit. Goodness. Oh, okay. Addresses, stuff. Good gracious. I don't have words for that. That, like, the amount of money you're going to spend in litigation does not outweigh paying less than $2,000 a year when you spent $300,000 to buy a URL. Just don't do that. Don't do that. All right, let's pull up Exhibit B. Ugh, I got logged out of Pacer. Of course I did. Of course I got logged out of Pacer. Why would anything be easy? Let me log back into Pacer and pull up Exhibit B so we can take a look. And then we're going to cruise through Girardi stuff, and then we're going to move on. All right. Taylor Swift. And yes, I will peek and see if there's anything else I need to look at before this. Let's pull up Exhibit B real quick. No, I want to do this. All right, Pacer. Let's go, baby. Where is Exhibit? Oh, wait, did I just pull up the wrong one? Yes. Of course I did. Why wouldn't we pull up the other one? Where is the other one? Not Utah. I want the Tennessee one. Come on, Tennessee. Let's go. This is what happens when you have too many Pacer tabs open at once, is that you have to pull up all of the things. All of the things. All of the things. All right. Let's pull up the Tennessee case, not the Utah case. The Utah case is not helpful at all. And pull up Exhibit B. I really want to know. I want to know. All right, now you're saved. Docket report. I should just pull this up on the screen while I'm pulling up Pacer, but it is what it is. All right. Pacer, Exhibit B. Let's view it. There we go. Oh, all the letters. Tell me this is exactly the same thing. Yep. It's just a different date, 9/18/2019. I note that BMI has been contacting you for some time regarding the necessity of signing a BMI music licensing agreement. In the past, letters have been mailed to your attention reflecting your licensed music fee of $1,700 from May 2019 to December 2019 only. This fee does not include all other unlicensed periods. This is not like a company that is spending hundreds of thousands of dollars in advertising to just not file this. It makes absolutely zero sense to me. It makes zero sense to me. All right, we're going to Girardi update real fast, and then I'm going to answer questions, because what is this? What even is this? What even is this Taylor suit? And we're going to chat about it in the chat in just 1 second, because I promised Girardi updates, and we're going to do it. Girardi updates. If you are not following the Girardi suit, I have a lot of content regarding the Tom Girardi suit. Tom Girardi, famous attorney in a lot of lawsuits. His wife, Erika Jane, is a real housewife. We've been talking about it because it's wild. There are clients of Tom Girardi that have not been paid. There are business partners that have not been paid. There is a forced bankruptcy, meaning all the creditors got together and went, you're bankrupt. We're going to court because we don't trust you to figure this shit out. I'm going to tell you the most interesting updates from the most recent filings that I have been tracking. One, the court said in the bankruptcy case, hey, Tom Girardi, I don't think you need a 10,000 square foot house. Yeah, you're sure not going to need that. We're going to need to go ahead and sell that house. They also said that they were abandoning property, which is interesting in a bankruptcy. It means that the bankruptcy court is like, we're not fucking with you. Like, if I don't talk to you, it means I don't fuck with you. That's exactly what's happening. We're abandoning property. It means this property we're not going to recover off of. We're not keeping it in bankruptcy. So if there's any liens on it, or there's any leases on it, or anything like that, those people can go after you separately, or they can just repossess the property. We don't fuck with you. So there was what looks like an office property in San Bernardino that is being abandoned by the trustee. Hey, we don't need you. Then in the status report, the shade of the status report, I'm going to pull it up so we can all see it in real time together, because the status report kind of laid out what's been going on. And what's been going on is a whole lot of Tom Girardi not doing the things that they're supposed to be doing in bankruptcy. Because in bankruptcy, you have to file all the shit that you own. You have to file a schedule of everything you own. If you've watched Big Little Lies, it's in there. You have to list every piece of clothing, every piece of jewelry, everything that can be sold, rental properties, artwork, all of the shit, cars, all the expensive to be stuff. I don't know. How much are hair extensions? Maybe those two. If they, could they be sold? That seems like a bad idea. But maybe there's a market for used hair extensions from Erika Jane. I don't know. Either way, you have to list all that stuff. It has not happened. The debtor is a plaintiff's law firm based in Los Angeles. Yes. On January 13th, the court entered an order directing entry into Chapter 7. The court said, you're in bankruptcy now, bitch. Let's go. The trustee and her counsel and financial advisor have been reviewing, investigating, and analyzing the debtor's practice. That is Tom Girardi's law firm. This is regarding the law firm particularly. particularly, and the state of its financial and business affairs. The debtor likely has numerous secured and unsecured creditors, and the trustee is aware that the debtor is the subject of various pending litigation. The debtor also has a significant caseload. That means ongoing people, ongoing clients, ongoing people that have cases pending whose attorney is now completely MIA and in bankruptcy, who are seeing this play out in the media and have no idea what's going to happen to their cases. Those various pending litigation and a significant caseload. A lot of people, a lot of people going through a lot of stress because of all of this, which comprises most of debtors' assets. The cases are at varying stages, including some that have been resolved and some that haven't. The trustee has been working to sort through all of the data and gather all the details of the debtor's business. This is the law firm. This review process is continuing, but given the number of cases and debtors' inventory, the state of debtors' record keeping, and the lack of any personnel at the debtor, at the law firm, that is knowledgeable and familiar with the debtor's assets, liabilities, and financial affairs, and the difficulty of accurately ascertaining the debtor's assets and liabilities from the records, the task of compiling the information to prepare the debtor's schedules, those are the things that have to be filed in bankruptcy, the schedules of assets and liabilities, and the statement of financial affairs will be labor-intensive and time-consuming. This is where it is. The trustee believes that she can complete her review and prepare debtor's schedule within approximately 6 months. 6 months. 6 months. We said that. We said it was going to take a while. 6 months to get the schedule together. For the law firm, they also have to do it for the individual. So they have to do it personally as well. 6 months. And yes, this is the name of the law firm that's representing. This is the name of the law firm. The law firm is named Smiley Wang. Yes, I've never seen a law firm named Smiley Wang. It made me smile. 6 months, y'all. 6 months. 6 months for the business assets. This bankruptcy is going to take forever. 6 months. What also happened in the bankruptcy case is that the brother who was trying to act as Tom Girardi's guardian was noped right out of that. The court yoded him. You are not going to be the guardian ad litem, but there are proceedings going on for conservatorship, so that is running separate. The divorce has been updated about the bankruptcy. The bankruptcy is having impact on the Lion Air cases that are filed by Edelson PC in Illinois. With regard to Edelson PC, there is a new minute order with declarations that were interesting, but the most interesting thing was the joint status report. And so the Edelson PC case kind of tipped this all off in the media. It's a law firm that worked with Tom Girardi on that air crash. And they brought it to the court saying, yo, these cases have settled and the clients haven't been paid. Where is the money? Show me the money. Where did the fucking money go? And in the joint status report, do you know what they said? They said that EJ Global LLC, Erika Jane's company that they alleged to have received a $20 million loan from Tom Girardi's law firm, has been served in this case, but they haven't responded. And they have now defaulted in that part of the case. And Tom Girardi and Girardi Keese, the law firm, have not been served because it stayed to bankruptcy. So the bankruptcy court has stayed him being served in this. And that Erika Jane has not been served because no one can figure out if the bankruptcy stay affects her or not. So what's going to be happening in that case is that they are going after EJ Global LLC, Erika Jane's company, but they are still trying to figure out how much the bankruptcy is affecting Erika Jane as an individual, given everything that is going on. And that is a very, very quick summary of the Girardi case. And we are going to get to questions. I know that I have missed some of your super chats. I'm going to try to pull them up on the back end here so I can see them as we talk and try to get to some of those real quick. And then we're just going to get to everybody's questions. So it's time for questions. Let me see what I can pull up in the back end. Hi, guys. Can you believe this shit? Can you believe this shit? Can you believe this shit? Oh my God. Adam, thank you, bestie. It's good to see you. I'm listening and working some OT right now, and dude, Smiley Wang. Yes, Smiley Wang. And it just, again, I get very juvenile when I'm looking at lawsuits, and I'm like, that is, it's last names, but also I want Saltsy and Fucks to be in one law firm so they can be Salty Fucks. I think it's hilarious. Oh, his real last name is Salts, but still, I think it would be funny. I think it would be funny. I am easily amused. All right, I'm going to pull up some of these super chats on the back end of my YouTube because I think I can see them if I do this right and go through real quick and say thank you, thank you, thank you. Michael said, what is the relief request? The relief request for the which the Taylor lawsuit was to license the music and pay for the music. Baby Goose said, finally caught alive. You're the best. Thank you. Matt Bond, 4 albums, Lover, Folklore, Evermore, and Fearless. I imagine that goes to how many things she has to do on tour. Maybe it's just the 4 tour. Just call it 4. If there's 4 albums she needs a tour on, just be like 4. Jennifer Foster, please send good vibes to Law Nerd Mel and Paw Nerd Jasper, who ended up in emergency at human and pet hospitals yesterday. I'm so sorry, both Law Nerd Mel and Paw Nerd Jasper. That is very stressful. Emily, thanks for bringing us joy, amazing phrases, and facts, not fuckery. You're welcome. Kathy said Evermore LARP has been around for darn near a decade. And they've been interactive the last 2 or 3 years, long before, or been inactive long before the pandemic. Interesting. They say they opened in 2018. So that is what it is. Love this live. Emily D. Baker, your mods rock tonight. Our mods rock every night, but they really do keep the chat on topic because I have asked them to help me stay on topic. And so them keeping the chat on topic helps me stay on topic so I don't wander off and then not answer the things I intended to answer. So the mods very much help execute my vision for keeping the chat a place where we can all have just a lot of fun and have a good chat and enjoy it. Thank you, Tina Anderson, for the super chat. I didn't see a phrase in there, but thank you very much. Metrical asked for an old case. I don't know that case. Somebody asked if there was a Zillow. Teresa asked if there's a Zillow listing for Evermore. I have no idea. Rena said, may I humbly suggest Don't Stop Me Now? Yes, you may. Don't stop me now, because I'm having a good time, I just completely blanked on the words. But yes, Don't Stop Me Now needs to go into it for sure. Sarcastic KO lover said the countersuit is telling mom that they're wrong, but this is a situation where TES went to the other room and told dad that they're wrong. Yes, that is a perfect breakdown. They went to the other parent. Matt Bond said she's already moved on to Fearless Tay's version. Thank you, Matt Bond, for all the super chats. I appreciate you. And then I got to the other ones. Okay, so I think I'm caught up. Yes, I think that I'm caught up. Thank you for the super stickers. Any behind the scenes stuff we missed with the special guest? I'm always curious about the pre and post chat. Oh, Scott and I chatted for an hour. Scott and I last week chatted for an hour after the live stream ended, just catching up about life and creator life. What it's like being a creator, what it's like growing as a creator, how you make space for being a creator, and how we value what we do and how that has shifted. It was a really fun chat. So yes, we talked for quite a while. We will definitely have Scott back and talk creator things, movie things. I love those kinds of chats. And Scott is just such a fascinating guy with great stories. Evermore can only buy ads in front of the BuzzFeed Bring Me video if they spent advertising dollars to BuzzFeed. Very cool. Victoria, thank you. All right. Let me go. Oh, it just started raining for sure. Let me continue on. Don't Stop Me Now. I know the words. Yes, I know some of the words. Once we get past having a good time, I'm a rocket ship. shooting to the moon, I think. But I will buff up on my Don't Stop Me Now so I can get Don't Stop Me Now. What's going on with the Tory Lanez case? Is it going to trial or what? I'm confused as to what's going on. Can you help clear things up? I know he was supposed to be in court. Let me see if there was a new release regarding it, because I think the new DA policies are going to affect what happens in that case. Tory Lanez is also being represented by Sean Hawley, the same attorney that is representing Shia LaBeouf, LeBacon. Could we go with LeBacon? Because LaBeef, last time people were like LaBeef, and I'm like, let's just go with LeBacon. So let me see. There was a court date, and I have been pulling up other stuff because digging through the amount of documents in the Girardi case is kind of time consuming, to be perfectly honest. And I had business things I had to do this week too. So I had not pulled up the Tory Lanez case. Judge denies Tory Lanez request to speak publicly about the Megan Thee Stallion case. Well, yes, I'm not surprised by that. Let's see what Complex says about this. We're just going to pull it up together and see. This case is pre-preliminary hearing, so I don't know if anything happened in the last court hearing, but let's find out real quick. As reported back in January per legal documents obtained, well, yes, he asked the court for a modified protective order preventing him from publicly speaking on the case. The motion from Lanz's team argued that, in their opinion, it was unfair that Megan could use her respective platforms to address the case while he was barred. I understand that argument. The protection order in the case in question restricts Lanez from contacting Megan via social media. Yes, all protective orders do that in any case of violence where a protective order is issued. According to a report from Page 6, a judge denied Lanz's request during a hearing on the case on Thursday. Lanz's lawyer, Sean Hawley, argued at the court in LA Thursday, per the report, the order was unfair to her. Sean is a her. To her client. Anyway, the judge oversaid. I hate it. No, not anyway. I hate it when media outlets assume that lawyers or judges are male. Why are we assuming? If you don't know, use they. But Sean is a woman, a powerful woman. You can Google her. She's been on TMZ. I am done digressing. Previously, a false story was widely circulated. Fine. What did media relations say? Not only would Megan not be dropping one of such charges, a rep from the LA District Attorney's Office confirmed that the case was unchanged at the time and pointed to a hearing date set for February 25th, today. I wonder, they're going to probably drop these firearm charges because the gun allegation doesn't go along with the new guidelines, but I guess we'll see. What did the Page 6 say? Well, he can't talk about, he's a defendant. Victims are not necessarily, victims aren't beholden to the court in the same way that defendants are, because the court doesn't have the same type of jurisdiction over them. It's different than a civil lawsuit. In a civil lawsuit, both parties are under the court's jurisdiction, but it's different in a criminal suit. Oh my God, Corksicle, yes, I love you, I get it, but geez. Let's see. The court ruled that he can't publicly comment on the case. He pleaded not guilty. He filed a request in January. Lanez's attorney, Sean Hawley, argues that the protective order is unfair. I mean, I get it. There was false reports that the charges had been dropped. They hadn't. There was an Instagram rant in October. So not much has happened. This is still set pre-preliminary hearing. I imagine what will happen in the coming months is that evidence will be turned over. The defense will sit down with the DAs and try to resolve the case. If I was Sean Hawley, I would go to the DA's office and be like, your boss issued new regulations, so you need to drop the gun charge, you need to change some of the charging documents, and we want a deal. If I was the defense attorney on that case, that's what I would do. And if I was the DA on that case, I would be interviewing everybody that I could find to lock in their statements before this case got any more publicity. So it is still set pre-preliminary hearing. When there is a preliminary hearing, which have been going a bit slow because of COVID in Los Angeles, then witnesses can come in and testify. The preliminary hearing means, yes, there's enough for this case to get ready to go to trial. We're at the very, very beginning stages of that criminal case. I was referring to that in January 2020, a lot of insurance got rid of the pandemic coverage in event insurance. Okay, thank you, Tina. Appreciate it. Oh, my chat jumped. Hold on. I gotta get back. Gotta get back. All right. Always more queen. Fantastic. Let's see. Scott needs a channel. Scott has a channel. He's just not active. Scott needs to be active on his channel. I think he's pretty swamped with work for voice work, but I want him to post. What Scott really needs, no, what Emily wants Scott to do is be on TikTok more and do his little like voiceover sketches on TikTok. I think it's perfect for like Instagram Reels and TikTok because he does such funny voice bits. I think that'd be really fun. Question: how does the whole Taylor not owning her music impact the lawsuit? I thought that was her whole issue with Scooter Braun and why she's re-recording with slight differences. She owns a lot of the copyrights because she owns the copyrights to the lyrics. So she is a copyright owner of her music. But I don't remember which label Braun owns those through now because they were sold again to someone else. So yes, there is also another copyright owner that can benefit from this suit, but it's really like pay BMI for fuck's sake is what's happening with that. What is the strategy behind EJ LLC not responding? I have no idea what the strategy is there. I don't play with federal judges. Like I don't fuck with that. You can respond with things like we need more time. You can respond with things like we can't answer, we're doing investigation, but just not responding and defaulting is not, I don't understand that strategy, but I guess I don't understand everything. And that's, I don't understand everything. I don't understand that strategy. She knows this is happening. There's no way she doesn't know that this is happening. Her company has been served and they know that this is happening. The company, it's not her. Her company has to respond unless the goal is to just let the company go bankrupt and be like, well, the company's going to go bankrupt, so I don't really care if there's a judgment against it. That's outside of my comfort zone. That is outside of my comfort zone. Not interested has a question. 1, Utah Business article 82120, Evermore faces financial ruin after failing to pay contractors. And 2, 100K GoFundMe 82520, helping Evermore through COVID. 3, lawsuit against Taylor Swift, desperate, ? I appreciate how you got that all into the character limit of the YouTube questions. Taylor Swift's team has pointed to this and pointed this out in their letter responses to Evermore, that's in my other video, and in their responses to the media saying Evermore has other financial woes that aren't just us. So that is definitely the Swift position of the case, is that Evermore has overspent, COVID has shut them down, and now they're behind and they're trying to cash grab at Taylor Swift. That is absolutely the public-facing Swift perception of this case. Did you hear about the house Britney Spears got bad vibes in and sold? Brittany Murphy ended up buying it. It was the house that she passed in. Serene, I hadn't heard that. What was I watching about Brittany Murphy not that long ago? It's very weird about the Brittany Murphy death and then her boyfriend dying as well. Just odd stuff there. But no, I didn't know that. And that is also very, very interesting. Thank you. Would it be illegal for me to sell dragon eggs with Taylor's hair glued on under the name Evermore? Oh, Sounds Design. That's very funny. I would like to know how you get Taylor Swift's hair, but there is a difference between parody and things that are protected. So there is a difference, but there are definitely lines of using someone's likeness to sell things. So it just really depends. Is the Evermore lawsuit really about the trademark or wanting to be in the public eye? I think we're entering an interesting time where lawsuits are also PR. The thing that's interesting to me is that Evermore Park chose to go ahead and sue Taylor Swift, knowing that BMI was in their butt about paying for licensing. Like they knew that. Before they chose to sue, they knew that. And then they did it anyway. Crazy to me. Crazy. This is how far behind in the chat that we are just at having a good time. So I'm going to catch up real quick. If I miss some things, I am sorry. Do we need a LaBacon emoji? Maybe, Emily. Maybe we need a Shia LaBacon emoji. Bacon, bacon, bacon. Yes, we can have a LaBacon emoji. I just need to figure out how to. Well, there's that bacon emoji, Lauren. That definitely works. Question, when is a follow-up on the PPP round 2 coming, or did I miss it? Cherie, I talked about it briefly on Tuesday. It'll be timestamped on Coffee and Cursey Words because those are available to some businesses to apply for now. So Tuesday, it's timestamped from Coffee and Cursey Words. Thank you for asking. There is more PPP. I act like bacon, baby, every time I eat bacon. Bacon! Oh my God. That, of all of the comedy sketches in the world, comedy around food always makes me happy. And bacon, bacon always makes me happy. We're going to have to move on. I'm going to do a few more questions and then we have to get to court of public opinion or I'm going to talk forever, which I kind of already have. Will you guys let me know? We have over 2,500 law nerds in here. Will you guys do the YouTube things? Because it's been an hour and 45 minutes and I haven't asked, like the thumbs up things and the likey things or whatever. And then I should also do the other things. If you guys have not joined the text crew and you're in North America, textemily.com. I have some things coming that I'm going to be letting the text crew know about first. So if you have not done that, you can just you can put in your browser on your mobile device, text Emily, and it will just literally open up the window. I also added it on Twitter, but if you do it, it literally opens up. I'll show you what it opens up. It literally opens the window so that you can just join text Emily. So I'm going to go to my Twitter so I can hit the link and show you. But it's in one of my latest tweets and it just opens up this window so you can join the text crew right there. So if you go to text Emily on your phone or if you're on my Twitter, there is a link on it, hyperlinked. Anyway, you can go do it there, but it just opens right up on your phone and makes it real easy if you do it from your mobile device. So don't forget to join the text crew because I have stuff coming for you guys. And I'm very excited about it. Okay. Question. Do you think it's a legal strategy for Tom's side to make him look like some weak old man? Yes. That everybody's ganging up on? Also, yes. I saw him on Real Housewives of Beverly Hills last year and he was sharp as a whip. Yes. And charming and telling stories. So I don't know if that's why he hasn't really appeared in court. He's appeared by phone to say, I'm here, but that's really it. The bankruptcy trustee is not going to go easy on Tom Girardi just because they perceive him to be maybe under a conservatorship, because really it's about the estate. For the criminal case and for the public perception, there might be more of a PR play to having him in a conservatorship. He also very well could need a conservatorship. And the charming and telling old stories is because he could only tell old stories. And the newer stories he couldn't keep up with. But he definitely seemed to charm the pants off of all the women on Beverly Hills. And I will be interested to see how that plays out this season. I will be very interested to see what happens in Housewives this season. This is not going to turn into a Housewives commentary channel. I go on to other people's channels to do that. But I will be fascinated and I will be talking. That's the kind of stuff I really talk about on social. Like Twitter, I talk about other news stories like Lady Gaga and the dogs. And I will give those kinds of thoughts, the breakdown of Housewives and stuff on Instagram. If an accused tells their lawyer they did the event, can the lawyer still help the client claim innocence? If they're their hired defense attorney, yes, that's exactly what their job is. So yes, criminal defense is a very specific work, but criminal defense attorneys generally want to know what's going on. And that varies defense attorney by defense attorney. Some defense attorneys are like, I want to know your side of the story and let's prove the best defense. But also, Legally Blonde covers it pretty well. It's like, I know her alibi, but I can't tell her alibi. And I'm not going to provide the alibi to the court, but I know there's an alibi. So now it's my job to poke holes in the story because I know that it wasn't her. So that end of Legally Blonde where she's prodding at the witness because she knows, Elwood knows that she didn't do it because she was getting liposuction. So Elle knows there's an alibi, but won't betray her client's trust to provide it in court, but then you probe. It's the same way. Even if for a criminal defense attorney, they know that somebody did the thing, they still have to prove that the evidence was collected properly, that due process was followed, that the witnesses are telling the story accurately and believed by a jury. It's their job, if a client they know has done the thing, to still make the system work and still ensure that the client has due process, ensure that the evidence was collected properly, ensure that the witnesses are properly cross-examined. That's their job. And if they know somebody did it and their client is found not guilty by a jury, it doesn't mean that they didn't do it. It means that it wasn't proven beyond a reasonable doubt in a court of law that they didn't do it. And that's where defense attorneys are like, that is my job. My job is to make it be proven in court. And that is a very interesting quirk that not everybody understands with our system, but it's the push-pull of our criminal justice system. Is there are two sides for a reason, to try to get to the middle, but it's the job of the government to prove beyond a reasonable doubt, lawfully and under the Constitution, that the person accused of the thing did the thing and should be convicted of the thing. Yes, Bella Marie, I will go over the changes with the LA District Attorney situation at some point. There are a lot of them and they have shifted some. So I am waiting to see how they continue to shift. There are also legal cases going on with that, and some of them have resolved already. A little off topic, any thoughts on the Twitter charging for views? I talked about that on Twitter. There goes a lot of EJs and other sponsors. True. Might also help start a lot of court case messiness. I don't know about that, but what I saw from Twitter is that Twitter is charging or allowing people to monetize in almost like a membership model, where you can have like members only tweets and not members only tweets. So it seemed kind of like a Patreon model to me, but of course there could be more. What we all want is Scott's TikTok handle. I know, but Scott said he has a secret TikTok. I want him to have a The Scott White TikTok for sure. So I hope that answers, a jaded person of 30 years. I hope that answers your question. So that's my understanding of what Twitter's doing. But all the platforms, like Facebook did this, they throttled the Facebook pages unless you were paying for ads and stuff. All of the different platforms are finding their footing in the wake of TikTok stealing a lot of the attention. So that's absolutely what's happening. So thank you, Big Machine. Yes, but Big Machine, Scooter Braun sold Taylor Swift's catalog to someone else. I covered it in other content. I'll have to go back and find where. So I have not yet seen the visuals for the Pokemon Switch game coming out in 2021, or 2022, but I will absolutely play it. I love playing Pokemon on the Switch. I love playing the Switch. It's such a great gaming device. So I'm going to keep on keeping on. Question: can we be done with people who stole Lady Gaga's dogs and people like her? Besides assault, do dogs represent property? How do you determine their value? What would the charges be? Oh, that's a lot of it's a lot of questions. I will try to do my best. I did address this on Twitter. In California, there is a grand theft of dog that is actually a subsection. The dog's valuation goes by kind of standard practice. So she has, I believe, I'm not even going to try. I totally forget the breed of dogs. I imagine her dogs would be worth more than the limit for grand theft. But also, the dogs are property for the purposes of the law. They were taken from the dog walker's possession and he was shot. So that becomes a robbery. For a robbery in California, you need the forcible taking, but the value of the property doesn't come into it. Like a robbery is not less of a robbery because a necklace is worth, $20 versus $20,000. It's a forcible taking from a person with that violence is going to be, I don't know if it would be an attempted murder. It depends on how the shooting went down, but assault with a deadly weapon for sure. Assault with a deadly weapon causing injury. The robbery at gunpoint with the, See, this is why it's hard because the DH restrictions have changed. So some of the things that would normally be added to the Lady Gaga dog situation, and maybe I should go through the Lady Gaga dog situation and be like, this is how I would charge it versus this is how it's charged under the new things. But some of those things would be like the personal use of a firearm, meaning a person had a gun and they shot you. Those are extra time. Those aren't being alleged anymore. So if they find who did it, it will be interesting to see what's charged. But yes, that is a robbery. So that is a robbery. Thank you very much. Red bag, read books. Can I get a whoomp whoomp? Boards passed today. What is PMHNP? I don't know. Boards passed today, but whoop, there it is. I don't think that's what you were asking for. Congratulations on passing your boards. That is a big deal. Yay. Evermore new defense. A check got lost in the mail. Maybe. Oh, the full moon is messing with everything right now, Kirby. I agree. Or Kibby. Sorry, I added an R. Apologies. A few more questions and then it's time for court of public opinion. For sure. Let me see. I am here. I am not a cat. I saw that. I am here. I am not a cat. Oh, you guys are the best. I have gone through Text Emily numerous times. I get the page you showed, but I do not see an option to join. Okay. Lisa, thank you for asking. Let me pull it back up. So I'm going to text Emily. We're going to do it live. All you have to do, well, I'm already joined. All you have to do is message and it will work. So I'm already joined. You should just be able to message it and it will join. So send a message and then add to contacts. We'll do it. But I've already joined my text messaging and I don't think I can unjoin and then rejoin, but it's in there. So that will do it when you tap the button and just send message. All right. One more question and then we're getting to court of public opinion. Question, may I suggest a LaBeef alternative, perhaps a LaBeef jerky? I thought we were going with LaBacon. French Bulldogs. Thank you, mods. French Bulldogs. Diva and Tech have let me know. French Bulldogs are a little bit, they can be pricey, especially if they're purebred. So I think a robbery for sure. We'll see what happens. We'll see if the people are caught. I hope they are. I can't imagine how stressful it would be. I think it would be a good example. I agree with you. I can't imagine how stressful it would be not to just have your pets taken, but to have somebody that you trust with your pets harmed like that in doing something for you. Like somebody is walking your dogs and they are shot. I can't imagine the stress. Look, in my family and in my personal life, I have lost people to violent crimes, and it's very, very stressful. And people surviving violent crimes, you feel so badly that that's what they're going through. I can only imagine the kind of emotional upset that this has caused for everybody. And for those that aren't like diehard pet people, it might be hard to envision, but it would really be like somebody trying to kidnap your kids from a babysitter and shooting the babysitter. It's not exactly, but it feels the same. So I can't imagine. I have tons of empathy. Okay, let's go to the court of public opinion. We're pulling up the tab from both the Twitter and the YouTube because we talked about it on community tab. And this is from last Friday, because we had not gotten it resolved. We had to go to a runoff. So let me pull up the community tab poll and pull up the Twitter poll so we can finally have an answer on who the court of public opinion thinks is the best Batman. So let me pull up Twitter too. Way to be prepared, Emily. We had Twitter up on the phone, but not up on the computer. Nah. Pull it up everywhere. You guys voted a lot. We had over 1,300 votes in round one, and we have over what is this? We have over 300 votes. We had 10,000 votes the first round, but we have over 300 votes this time on not Instagram, on the YouTube community tab, and over 1,500 on Twitter. So let's add that in. So Twitter says Christian Bale. Twitter says Christian Bale. Twitter says Christian Bale, 40%. Michael Keaton, close seconds. I'm sorry, Kevin Conroy and Will Arnett, but Christian Bale with 40%. And then on YouTube, Christian Bale with 44%. Lego Batman definitely pulled it up. And the others that are in the chat had gotten knocked out in round one. So we can't pull up the ones in the chat. These were the victors that we were voting on. So Christian Bale, then Michael Keaton, then Lego Batman, based on our court of public opinion. That's what it is. That's what it is, y'all. That's what the court of public opinion has decided, that they do not hate Christian Bale's weird Batman voice and that he is the best Batman. I think he benefits, though, from having the best franchise of movies. I do think that definitely swayed the vote on Christian Bale. And then we have to quickly ask this week's court of public opinion question. So let's get into that. And then we're going to do a quick wrap up because we have been live for 2 hours. You guys, I'm just going to step into controversy. I am. I'm going there. Like, I woke up today and chose to fight. And it hurts me to bring this court of public opinion, but we've been asked for it. I think we need to talk about it. Like, my kids are already divided over it. Star Wars. Prequels, main series, or sequels. We are just going with the movies, because if we throw in the Star Wars stories, it's going to fuck everything up. We can do the Star Wars stories another day. Star Wars, court of public opinion, what is best? The prequels, the sequels, or the OG main series movies? So we have groups of 3 movies. We're going to vote. We're all still going to be friends at the end of this. If anyone comes up to vote with this and says Star Trek, I can't with you. Don't choose violence. Don't choose violence in my chat. Main series, prequels, or sequels. You guys know how we do it. We are going to have a conversation about it on Twitter and here on the community tab to see what the court of opinion says. And then we are going to rule, hopefully on Tuesday, because I don't think we'll have a runoff because there aren't as many options. Then, if we want to, let me know in the comments if you want to do next week's the Star Wars spinoffs. If we talk about what is better, Clone Wars, Mandalorian, the Solo story, Rogue One, talk about those. But oh, you guys are like, no, we're going OG. See, somebody was going to choose to fight. It's all in good fun. You guys are OG. We will do a Star Trek, Star Wars another time. We will. OG. Wait, what does that mean? OG means original franchise. There are the prequels, there are the sequels, and there are the original franchise. So you got to let me know. Is it the main series, prequels, sequels? I'm going to put these up on the socials. If you don't follow me on the socials, please come follow me on the socials. I feel like we have fun. I posted a reel of me as Lawyer Cat. That happened, you guys. That happened. I did. I posted me as a cat. I did. I posted me as Lawyer Cat on social media. So if you don't follow me on social media, now is the time. Of course, I've put up the wrong thing. It's not that. It's at the Emily D. Baker. Just come follow me. Come follow. I'd really, really like to. I'm at almost 18,000 on Insta, and that would be fun. So come follow me on the socials. Lawyer Cat would like you to follow on the socials. Please, please, meow. And join the text crew. We talked about it. I hate to say this, but I'm going with the sequels. You can go with the sequels. It is the court of public opinion. You can. All right, you guys. Court of public opinion. I'm going to put it up everywhere. We're going to vote on it. Do the lawyery things. Go ahead and subscribe if you're not subscribed. Thank you for hanging out with me tonight. We're at 87,000. Purple hair's coming soon. Do the YouTube things, do the social things, and we will be back here live on Tuesday, providing that nothing else pops off. Let's all have a quiet weekend. Let's do the things. Let's have a quiet weekend and do the things. It's going to be lovely. It's going to be great. I appreciate all of you. Thank you so much for being here. We're going to wrap this up. It's been 2 hours, you guys. I appreciate you. Thank you for being here. I've said that 900 times. Let's just wrap it up. I will see you guys on Tuesday. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.